Law School. He's a member of the Board of Directors of the Environmental Law Institute and the Lawyers Committee for Civil Rights Under Law, and is past chairman and president of the Sierra Club Legal Defense Fund, now Earth Justice. He's been an adjunct lecturer at Bolt Hall Law School at the University of California, Berkeley, where he's taught remedies and conflicts of law. In 1995, Mr. Traynor was named by the American Association for the Advancement of Science as a fellow for research and publication on issues at the intersection of science and law in biotechnology, the environment, and information technology. In 2002, he was elected as a fellow of the American Academy of Arts and Sciences, and his most recent honor, which came after the publication of the program, is that he received the Ninth Circuit Professionalism Award, which is very special to our law school because it's named after one of our graduates, the late John P. Frank, class of John Skilton and I were speculating, and I'll look to Ed for resolution 39 or 40? 40. And finally, as someone, I should have introduced myself for those of you who don't know. I'm Ken Davis. I'm the dean of the law school, and as someone who has probably gotten an unfair share of job opportunities based upon the mistaken assumption that I have something to do with the preeminent administrative law scholar Kenneth Culp Davis, which I don't. I should add that our speaker today is, however, the real deal. All of us, I think, as part of our legal education, read numerous opinions by the distinguished Chief Justice Roger Traynor of the California Supreme Court. I know I still regularly teach one, Minton versus Cavani, if you remember that one in my corporations class. Mike Traynor is the Chief Justice Traynor's son. So it's a wonderful honor to welcome to our law school Michael Traynor.
It really feels good being back in a law school classroom again. I love to teach, and this atmosphere is just terrific. When we came in at the airport, Shirley and I, my wife Shirley is right here, and got into a cab, the cab driver asked us where we were from. And Shirley said, well, we're from Berkeley. And he said, well, Madison's the one town in this country that makes Berkeley jealous. Which I take it as a compliment to both our cities, so it's a great pleasure to be here. I'm also glad to see my ALI counsel colleague Diane Wood, who's on the Seventh Circuit here with her husband Rob. That was a very special treat and pleasure. And I'm delighted to be here in Madison and to honor Judge Thomas Fairchild, a magnificent citizen of Wisconsin who has devoted his life to distinguished public and judicial service. I'm grateful to be in your friendly company and grateful to Dean Kenneth Davis, Jr. for this generous introduction. Thank you. The last time I visited Madison was in 1996 to see Shirley Abrahamson when she was sworn in as Chief Justice of Wisconsin by Chief Justice of the United States, William Rehnquist. Her Fairchild Lecture is a brilliant analysis and portrait of the American Law Institute. It is a special pleasure to be here at the Law School of the University of Wisconsin. UW-Madison has identified as one of its key strategic directions the strengthening of its commitment to public service, including the concept of citizenship, which emerged as critical in the university's self-study. I salute the many contributors to the positive spirit of Wisconsin citizenship, including United States Senator Russell Feingold, who had the courage to cast the sole dissenting vote in the Senate against the so-called Patriot Act, to which I will refer later. I think there's a little slide here, too, from the day's newspaper. Sarah. Maybe somebody will help me put that on in a minute. Thank you. I should know how to work these. Oh, there it is, right there. Thank you. You see that? It's a timely cartoon. This remarkable group of Wisconsin citizens also includes your Governor Jim Doyle, former Senator Gaylord Nelson, former Governor Tommy Thompson, the late Judge and State Senator Robert W. Warren, Judge Barbara Crabb, John Frank, my dear late friend and ALI colleague, and John Skilton, our prized co-chair of the Lawyers Committee for Civil Rights under Law. 2 years ago, here in Madison, Tony Lewis gave the Robert W. Kastenmeier Lecture entitled Civil Liberties in a Time of Terror. My talk today is entitled Citizenship in a Time of Repression, and it addresses the responsibilities of citizens in safeguarding civil liberties. I considered whether to select a blander, less provocative title, but decided that I could not do so, for I feel that in my heart that our rights as citizens to the truth and to basic liberties are being repressed by our own government, and that we have to stand up against this erosion of our liberties. As an idealistic 10-year-old, I observed the formation of the United Nations in San Francisco. Gathered on the stage at the Opera House, world leaders worked diligently for an international structure promising a beleaguered world, security and peace, as well as human rights. As a teenager, I began to develop what has become a dual and lifelong commitment to our environment and to liberty. I believe that the preservation of each is important for the other, and that governmental oppression of our environment is likely to be joined by governmental repression of human rights. In 1950, when I was 15, I spent the entire summer hiking in the Sierras in California and appreciating the freedom of being one with the mountains, lakes, and streams. The next year, I was fortunate to be a freshman at the University of California at Berkeley and to begin classes with one of those remarkable teachers who influence one's entire life. Professor Jacobus Tenbrook, a constitutional lawyer and scholar, introduced us to principles of liberty and equality, to the Socratic method, and to issues of freedom of expression. We also studied the Hirabayashi case, which upheld a military curfew against persons of Japanese ancestry, and the Korematsu case, which upheld their forced relocation during World War II. Both cases were early examples of governmental overreaction to perceived threats. Today, the word patriot is used in a statute that, in my opinion, stifles liberty. The term collateral damage is used to describe the deaths of children and other innocent bystanders. The phrases weapons of mass destruction, immediate threat, and imminent threat were used by our government to justify a war. Phrases that have prompted disturbing questions and unresolved questions about the evidence upon which the government acted, as well as about knowledge and intent. As an environmentalist, I am appalled to see a measure that would increase pollution falsely described as a clear skies initiative, and a measure that will deplete forests called the Healthy Forest Restoration Act. Our government is blatantly misusing the language. George Orwell's prescient warnings against newspeak and doublethink are as apt today as they were over 50 years ago. Truth, liberty, and openness are related, as I will demonstrate by examining one of the most controversial provisions of the Patriot Act, Section 215. This section amends the provision of the Foreign Intelligence Surveillance Act that deals with government investigations and the power to obtain records secretly. Because members of religious groups know the FBI can now demand their personal records, even if they have done nothing wrong, some are already declining to attend mosques, make charitable contributions, speak about controversial issues, visit websites, or engage in other activity that might become the subject of a record. If not repealed or renewed, Section 215 will sunset with some qualifications on December 31st, 2005. Prior to the Patriot Act, the statute was limited to business records related only to common carriers and public accommodation, physical storage, and vehicle rental facilities. It also required the Attorney General to certify to a court that the records sought were relevant to an investigation and that there was reason to believe that the target was a foreign power or the agent of a foreign power. I will examine three aspects of this issue. First, what the Department of Justice and the Attorney General of the United States say about Section 215 in public relations statements on their official website and elsewhere. Second, what the statute actually authorizes. And third, what the Attorney General has admitted in sworn testimony before the House Judiciary Committee. The Department of Justice maintains a website reassuringly entitled Preserving Life and Liberty. There it posts the Patriot Act, speeches and reports, including one called Dispelling the Myths, describing Section 215 as addressing access to business records and other items under the Foreign Intelligence Surveillance Act. That report describes as a myth the statement that many people are unaware that their library habits could become the target of government surveillance. It describes as, quote, reality that the library habits of ordinary Americans are of no interest to those conducting terrorism investigations, and that obtaining business records is a long-standing law enforcement tactic. The department's website asserts that, quote, Section 215 has a narrow scope. It can only be used to obtain foreign intelligence information not concerning a United States person, or two, to protect against international terrorism or clandestine activities. It cannot be used to investigate ordinary citizens or even domestic terrorism, end quote. The website emphasizes that Section 215, quote, preserves First Amendment rights. It expressly provides that the FBI cannot conduct investigations of a United States person solely on the basis of activities protected by the First Amendment to the Constitution of the United States, end quote. In other public statements, the Attorney General has characterized the American Library Association's concern about Section 215 as hysteria. The department's Director of Public Affairs describes Section 215 as having only a, quote, narrow scope, as going to great lengths to preserve First Amendment rights, and as requiring a court order. A trusting reader of such public statements might understandably conclude that Section 215 is aimed primarily at business records, not at library or personal records, and at foreign terrorists, not American citizens, that it affirmatively preserves First Amendment rights, and that its application will be subjected to serious judicial review. Most readers and web surfers will likely not review the actual statutory language or the testimony of the Attorney General. The statute, however, expands broadly the definition of accessible records. It now extends to tangible things, including books, records, papers, documents, and other items. It explicitly authorizes the director of the FBI or his designee to conduct an investigation of a United States person, a term that includes a United States citizen or lawful resident alien. Although such an investigation cannot be solely on the basis of activities protected by the First Amendment, the term solely seriously limits the protection. Would you want to rely on the government's determination that you were solely engaged in protected activity and not in anything else? The statute plainly suggests that the FBI can investigate United States persons based in part on the exercise of their First Amendment rights without any safe harbor for such exercise. Moreover, the First Amendment limitation only applies to an investigation of a U.S. person. A visiting uncle from a foreign country, for example, could be the subject of an investigation, and while staying at his nephew's house here in the United States, the investigation could extend to the nephew's records. Furthermore, under Section 215, the government applies in secret to a designated federal judge or magistrate for a secret order. The targets are not notified that their privacy has been compromised. The government's application need only specify that the records are sought for an authorized investigation conducted pursuant to the statute. This standard is a most lenient one. The government need not show probable cause or even reasonable grounds to believe that the target of the order is a criminal suspect or foreign agent. The statute requires that the judge shall enter an ex parte order as requested or as modified, approving the release of records if the judge finds that the application meets the requirements of the section. The statute gives the judge no authority or leeway to require evidence or to go beyond a determination that the government's application itself meets the statutory requirements. Section 215 provides that the order shall not disclose that it is issued for purposes of an investigation. The person who is the subject of the investigation may never know about it. Section 215 further contains a non-discretionary gag order, a gag requirement that no person shall disclose to any other person that the FBI sought or obtained tangible things. In his testimony before the House Judiciary Committee on June 5, 2003, the Attorney General, in response to questions from Representative Tammy Baldwin of Wisconsin, acknowledged that Section 215 had expanded the records accessible. He agreed that the standard for seeking a court order was lower than probable cause. He admitted that the FBI could ask for book purchase records, a library book, or computer records, and that, quote, there are some education records that would be susceptible to demand, end quote. He conceded that probably the FBI could get genetic information, such as a little DNA left on a glass of water by someone who had committed a crime. The department similarly downplays the intrusive effect of other provisions of the Patriot Act. For example, the sneak and peek provision that authorizes government agents to come to a private residence in secret to look around, to take photographs, and even to seize property without the owner's knowledge. Notice may be delayed for a reasonable time, which may thereafter be extended by the court for good cause shown. In a democracy, the government is implicitly constrained by the informed consent of its citizens. When citizens visit the website of our Department of Justice, they are entitled to an objective description of the law, not an advocate's brief or public relations statements that omit crucial points or distort the language and meaning of the statute. We should remember the wisdom of Thucydides, who related the loss of clear meaning of words to the subsequent degradation and decline of Athens. The truth comes first. In the last few decades, our country has experienced several deplorable sequences of governmental deception. The Johnson administration's deception of Congress and the country led to the infamous Tonkin Gulf Resolution of 1964, to expansion of the Vietnam War, and to more than one generation's distrust of government. The Nixon administration's deception of Congress and the country in the Watergate affair led to demands for truth from many quarters, including notably from members of his own political party, and eventually to his resignation. The Reagan administration's deception of Congress and the country led to investigations and prosecutions concerning selling arms to Iran and financing the Contras in Nicaragua, and reinforced the public's distrust of government. President Clinton's personal deception about the Lewinsky affair led to his impeachment by the House and a trial in the Senate from which he emerged with history's asterisk attached to his name. Today's governmental assault on truth is joined with its assault on liberty. The Patriot Act is not the only example. The government's mass and long-term detention of prisoners at Guantanamo Bay, its detention of American citizens without bail or access to a lawyer, its assertion of power to label citizens as enemy combatants and detain them indefinitely without judicial review or legal assistance. Its corollary justification that allowing detainees a lawyer would impede investigations. Its notion that it can try people in military tribunals without strict limitations and the process that even murderers, armed robbers, and traitors are due. And its claim that even the Supreme Court of the United States cannot review its actions are all threats to our liberty. The Supreme Court may resolve some of these issues in pending cases. If these usurpations are not stopped, it seems only likely that the government's appetite for intrusion will grow. So far, however, the government has met little effective resistance. The government's assault on truth and liberty is joined with the government assault on openness and an insistence on secrecy. After 9/11, the Attorney General issued a memorandum to all federal agencies reversing the previous presumption of openness under the Freedom of Information Act and pledged his Department of support for denial of FOIA requests. Under his direction, the government secretly arrested and deported hundreds of Muslim and Arab immigrants after closed deportation hearings. The United States Court of Appeals for the Sixth Circuit held that secret deportation hearings are unconstitutional under the First Amendment. It stated that a government operating in the shadow of secrecy stands in complete opposition to the society envisioned by the framers of our Constitution, and that open proceedings with a vigorous and scrutinizing press serve to ensure the durability of our democracy. The Third Circuit held the other way, despite a thoughtful dissent. Notwithstanding growing concerns about secrecy, the government readily makes use of secret orders combined with gag orders, a dangerous problem exacerbated by the Patriot Act. The current repression is reminiscent of the 1950s and 1960s. In the early 1950s, although there were many pleasant days, the Berkeley campus was in turmoil over a loyalty oath required by the university. Brave, able, and patriotic teachers lost their jobs when they refused to sign the oath, which the Supreme Court of California eventually held invalid. The controversy cast a pall on academic freedom at Berkeley for decades. During that time, the FBI was also spying on J. Robert Oppenheimer and other nuclear physicists, even to the extent of listening in to conversations between Oppenheimer and his lawyer. Students in the ROTC, in which I was enrolled, were apprehensive about spending time in the area of Sather Gate, the campus entrance, where both soapbox speakers and surveillance cameras were located, lest they jeopardize their future military commissions. The repression at Berkeley did not end with a sudden burst of freedom in the 1960s, despite the notoriety of the Flower Children or the free speech movement. We now know from FBI records, released under the Freedom of Information Act after many years of litigation with the government, that in 1969 the governor of California planned for the destruction of disruptive elements on college campuses. FOIA documents show that Governor Reagan's legal affairs secretary met with the FBI to review plans to hound post-protest groups and to seek FBI approval of those plans. This lawyer, whom I remember as a seemingly mild and unassuming person, told the FBI that the governor's administration planned to bring building code violations against him, audit their taxes, and engage in psychological warfare. Beware the smiling face of repression. FBI Director Hoover placed his initial and wrote OK at the bottom of his agent's memo summarizing the nefarious plans. The FBI's scrutiny of the university even noted the following essay topic on a basic English examination. That topic was, what are the dangers to a democracy of a national police organization like the FBI, which operates secretly and is unresponsive to public criticism? Although many things have changed, that English professor's exam question is still relevant. Given today's climate and our Attorney General's interest in establishing secret police powers, one might expect that it would still elicit government scrutiny. My background and interest in free, honest, and open expression and liberty makes me skeptical of what I believe is our government's repression of truth and liberty in an overreaction to terror. Like many Americans, I believe that our country's essential values and interests as a free country are inextricably linked. The values of truth, liberty, and openness that I speak about provide the very foundation for public debate. Robust differences of view and varied and competing ideas about how international, national, regional, and local challenges can be met. These values are common ground in the writings and speeches of such senators as John McCain and the late Barry Goldwater, no less than in those of Patrick Leahy and Russell Feingold, all extraordinary citizens who otherwise may differ mightily on many issues of social policy. It is on that common and nonpartisan ground that I speak today. I have no illusions about the very real threat of terrorism. We have experienced 9/11, Spain has experienced 3/11, and at any time in some part of the world, including our own country, the bloody hounds of terror may again kill and maim innocent civilians and try to demonstrate their fanatical commitment and prowess and our corresponding vulnerability. Circumstances have changed materially since 9/11. The appropriate responses to terrorism, in my view, include smart and aggressive actions to gather, assess, and develop reliable intelligence, but not to engage in demagoguery or fear-mongering, to reform our intelligence-gathering processes and agencies, but not to blame our failures on bureaucracy, to educate our citizens, but not to assume a color-coded alert system stands for true education, to prevent terrorist attacks when we can, but not to make enemies around the globe, to develop effective crisis management and first response programs with the involvement of local and state police, fire, and emergency officials, and supporting citizen groups, to engage in constructive and respectful diplomacy, to foster international friendships and communications and cooperative actions, not antagonistic unilateralism, to increase our knowledge of and international supervision over nuclear weapons, and even to engage in military actions on limited occasions approved by Congress or the United Nations. The appropriate responses include some of the provisions in the Patriot Act itself, including, for example, strengthening criminal penalties and lengthening or eliminating statutes of limitation for certain terrorist crimes, improving the benefits and related procedures for public safety officers, and expediting the hiring of translators at the FBI. Our history provides some lessons about responding to violence and threats. These lessons include trying to limit the response to the emergency and not overreacting based on broad classifications, political, racial, or religious. In the Civil War, when the Union was threatened, President Lincoln, among other acts, suspended the writ of habeas corpus in an effort to restore order and disregarded the Chief Justice's order to release John Merriman, who had been arrested by Union troops for helping to destroy railroad bridges. Lincoln, in a special message to Congress, asked his famous question, are all the laws but one to go unexecuted and the government itself go to pieces lest that one be violated? Congress, which was not in session when Lincoln acted, later approved the suspension. A careful reading of history suggests that he took what he viewed as emergency action, trusting that Congress would ratify them and believing that he was acting consistently with his oath of office. Justice O'Connor has recently written that Lincoln did not use his power selfishly or arbitrarily and tried to err on the side of free speech. In other incidents, there was far less calibration of emergency action and far less justification. For example, Attorney General Palmer's raids during the Red Scare of the 1920s and the government's forcible expulsion into internment camps of persons of Japanese ancestry during World War II. How shall we, as citizens, respond to deception, intrusion, and secrecy? The Constitution employs the word citizen. That term is a solemn one, connoting active membership in the civil community. When the Constitution was formed and Benjamin Franklin was asked upon leaving Independence Hall what the framers had created, he said, "A republic if you can keep it." When Justice Brandeis issued his celebrated concurring opinion in 1927 in the criminal syndicalism case of Whitney against California, he said that those who won our independence believed that the greatest menace to freedom is an inert people, that public discussion is a political duty, and that this should be a fundamental principle of the American government. When Judge Learned Hand gave his famous speech entitled "The Spirit of Liberty" to new citizens in 1944, he said that liberty lies in the hearts of men and women. When it dies there, no constitution, no law, no court can even do much to help it. While it lies there, it needs no constitution, no law, no court to save it. Almost 50 years ago, in 1956, when I was in my first year of military service, and when our country was emerging from the McCarthy era, we faced the real and imagined threats of communism and a Soviet regime that had executed millions of people and enslaved other millions in hard labor. With reference to Learned Hand's haunting words, my father then remarked as follows: "The judges whose job it is to apply the Constitution must carry liberty in their hearts, even when other men have ceased to. Who is to say that liberty is dead in the hearts of men who are silent? Liberty is not lost suddenly, catastrophically. It is lost imperceptibly by erosion. Who is to say that it is irretrievably lost until it has died in the hearts of those whose job was to care that it lived in the hearts of others? It would be good to be able to count on our judges who, like Justice Jackson in the second flag salute case, held that the very purpose of the Bill of Rights was to withdraw certain subjects from the vicissitudes of political controversy, to place them beyond the reach of majorities and officials, and to establish them as legal principles to be applied by courts. Suppose, however, that the day comes when we cannot count on judges or legislators to protect our liberty. Surely it would be better to stand up to repression, to organize for the preservation of liberty now, while there are still judges and legislators and conscientious executives who may listen. Over 2,500 years ago, Heraclitus of Ephesus said that the major problem of human society is to combine that degree of liberty, without which law is tyranny, with that degree of law, without which liberty becomes license. We should ask ourselves, what responsibility do we as citizens have to preserve that balance if our courts, legislators, and executives do not do so? In considering the responsibilities of citizenship, the starting point is our Constitution. It balances legislative, executive, and judicial power, allocates authority between the national government and state governments, reserves unallocated power to the people, and establishes rights of liberty and equality that are unparalleled in the world and in large measure are enforceable by courts. It says hardly anything, however, about the responsibilities of citizens. The 13th Amendment prohibits slavery, but overall, the Constitution, including its amendments, is not structured to address duties of citizens. Even such a basic issue as whether individuals must identify themselves in response to a request from a police officer is presently pending decision in the Supreme Court. Under various statutes that Congress or the states have passed, and under the common law, individuals may have certain duties, ranging, for example, from serving in the military to stopping at a red light or being subject to liability for negligence in causing personal injury to another. The debate over whether a citizen has political responsibility, however, is ancient. It is a debate between, on the one hand, Epicurus, who is summarized by Jefferson, said, "Happiness is the aim of life, and the summum bonum is to be not pained in body nor troubled in mind." And on the other hand, Cicero, who reminded us that we are not born simply for ourselves, but share a responsibility to others, including participation and leadership in one's political community. The dichotomy between self-interest and altruism continues in modern terms. Our freedom allows us the choice to go bowling alone, to pursue individual pleasures without any sense of citizenship, community, or responsibility, and to just take and not give. It also allows us the choice to heed John F. Kennedy's eloquent plea in his inaugural address: "Ask not what your country can do for you, ask what you can do for your country." Do Americans want to become informed and involved? Or do they want to be like the person who, when asked if he knew the difference between ignorance and apathy, responded, "I don't know, and I don't care"? This debate reflects very important and sincerely held beliefs about what life should mean and what government's role in the lives of citizens should be. This country could not even have this debate or confront or appreciate our differences, however, if it did not have the rock of liberty upon which the freedom to differ is founded. Is there really cause for concern? Why not just be complacent, passive, and phlegmatic? Many Americans are not likely to be taken in by government duplicity and secrecy. Many still feel relatively secure in jobs and homes and are law-abiding. Many should not yet have to worry about being packed off to a detention camp or compelled to talk about beliefs or friends before some hostile interrogator, or subjected to secret government surveillance of personal records and residences. Why should Americans care if some misguided person or minority or radical or alien gets caught up in a secret investigation of clandestine activity or detained indefinitely in some offshore prison? To me, however, it is all the more insidious that the repression occurring now is mainly felt by aliens, those on the fringe of society, citizens with radical views, victims of invidious discrimination, and people who may not be so law-abiding. Government will aim first at the weakest. It will target those who lack public support and against whom there may be a majority of opinion. It will not aim first at the strong or those whom the public supports. Ironically, it has often been the outsiders and the weak who have been the defendants in Supreme Court cases that now stand as beacons of liberty for all of us, such as the second flag salute case, the Gideon case, the Miranda case, and the recent Lawrence case, to name just four of many. Liberty does not defend itself. It requires individual defenders and advocates. Free Americans should not leave the defense of liberty just to those yearning to be free. In defending the rights of aliens because they are fellow human beings, even though they are not citizens or entitled to the full range of constitutional and statutory protections, Americans can also discover and express our own humanity. Even the slightest unjustified intrusion on liberty requires a vigilant response. The direction of the Constitution aims towards greater liberty, not less. These 2 points are clear in the Supreme Court's jurisprudence, and particularly well illustrated in 2 cases spanning over 40 years. In 1961, in Silverman against the United States, the court, in an opinion by Justice Stewart, held that the actions of police officers in attaching an electronic device, a so-called spike mic, to the heating duct of a house owned by the defendants, thereby turning the duct into a gigantic microphone running throughout the entire house, violated the Fourth Amendment. Accordingly, the conversations overheard by the police officers were inadmissible in evidence. The court had to confront an earlier case, Goldman against the United States, which held that the placement of a detective phone against an office wall in order to hear conversations going on next door did not violate the Fourth Amendment. In distinguishing Goldman, the court said, what the court said long ago bears repeating now. It may be that it is the obnoxious thing in the mildest and least repulsive form, but illegitimate and unconstitutional practices get their first footing in that way, namely by silent approaches and slight deviations from legal modes of procedure. We find no occasion to re-examine Goldman here, but we decline to go beyond it by even a fraction of an inch. The court in later cases has adopted the same vigilant approach. In 2003, in Lawrence against Texas, the court held unconstitutional a Texas statute making it a crime for two persons of the same sex to engage in certain intimate sexual conduct as it applied to adult males who had engaged in the consensual act of sodomy in the privacy of their home. In his opinion for the court, which also overruled a contrary precedent, Justice Kennedy said that as the Constitution endures, persons in every generation can invoke its principles in their own search for greater freedom. Although there is an ebb and flow to citizen participation and citizen resistance, quite different things depending on the times, in times of repression in particular, there are many things citizens can do to resist deception, intrusion, and secrecy, as well as contribute to the debate over values and how best to combat terrorism. Become informed and vigilant, participate in various venues of community opinion and debate, such as the internet, thereby contributing one by one to a growing consensus in the country and in the world. Mobilize city councils and state legislatures to speak and act for liberty. Serve on local boards and commissions and in nonprofit organizations, and help recruit good people for government and civic service. Vote and urge neighbors, friends, relatives, and co-workers to register and vote. Educate ourselves about threats and terrorists and how to deal with them. Train and enlist others, such as signing up in advance to be neighborhood watch captains, first aid givers, or stretcher bearers, for example. Ask our press and other media to be inquiring and perseverant and not lazy in their reporting. Demand due process for both citizens and resident aliens, and at the very least, rudimentary fairness for non-resident aliens. Demand of our senators and representatives that they repeal the pernicious provisions of the Patriot Act. Tell the president that he is wrong to demand renewal. As former President Theodore Roosevelt said during World War I, it is absolutely necessary that there should be full liberty to tell the truth about the president's acts, and that the notion that there must be no criticism of the president or that we are to stand by the president, right or wrong, is not only unpatriotic and servile, but it is morally treasonable to the American public. Protest the government's unjustified invasion of our liberties, even when, especially when, that invasion is just a fraction of an inch. In a time of terror, Americans may have to suffer some temporary and carefully calibrated intrusion on civil liberties. No intrusion should be permitted, however, unless there is a true emergency, and then it should be under the watchful supervision of a court or Congress and limited in time. Americans are a self-reliant and resilient people. We do not need to be coddled or protected by the government from unpleasant information. In emergencies, our natural instinct is to reach out to help others. Americans can be told the truth about what the government knows and does not know in a forthright way that does not compromise secret intelligence or military operations. We can demand government information under the Freedom of Information Act. We can challenge unconstitutional orders and unconstitutional provisions of the Patriot Act. The lawyers and scholars among us, in particular, can help sort out the legal issues of liberty and security and pick up the slack left by an attorney general who gives priority to secretive law enforcement instead of to the guardianship of our Constitution. A key challenge is to define those areas that should be governed by principles akin to criminal law enforcement with the attendant significant involvement of judges, and those areas that should be governed by principles akin to military action, foreign relations, or national security, with less significant involvement of judges, but perhaps correspondingly more congressional oversight, as well as executive oversight through inspector generals. Lawyers and scholars can help as well provide the rationale for determining who, including judges, decides which principles apply. Bar associations around the country can call on our president to speak the truth, as the Bar Association of San Francisco and many others did in 1973 during the Watergate affair. I call such expressions and actions literally and figuratively the footsteps of Americans. When representatives hear those footsteps, not just once or twice or here or there, but every day pounding in a crescendo of strong beats, then maybe they will begin to do what is right. Doing what is right usually calls for balance, sometimes also for neutrality. I have spoken today primarily about repression and overreaction by our government. Assaults on truth, liberty, and openness do not necessarily come exclusively from one part of the political spectrum. The words freedom now can ring hollow in the mouths of zealots from the right or the left who would overturn our system. Efforts to obtain truth or protect liberty or obtain government information often fail, as I can attest with an illustration from my own practice. A scholar who was studying the forced repatriation of anti-communist Russians to the Soviet Union after Yalta and at the end of World War II invoked the Freedom of Information Act to request an old but classified Army file entitled, aptly enough, Operation Keelhaul. On his appeal from the trial court's denial of his claim to see the file, we urged that a court should review the challenged classification. The court, however, upheld the government's claim of secrecy, and shortly thereafter, the Supreme Court itself rejected a similar claim in another case. It is important to recognize that not every citizen's effort will succeed. Many will fail or be thwarted. In my view, however, that is all the more reason for continuing to try, despite disappointments. Some good efforts will succeed. Earlier, I mentioned a few of Wisconsin's many great citizens. I would like to mention 5 examples of other citizens who are contributing to liberty in important ways in this time. Each person finds a way to make a difference and make his footsteps heard. First, the police officers, firefighters, military troops, medical caregivers, and others who are called on to respond to acts of terrorism, as in Oklahoma City and at the World Trade Center. Second, my law school classmate and study mate, Senator Paul Sarbanes, who recently has contributed immeasurably to improving corporate behavior through the Sarbanes-Oxley Act. He has strived so far unsuccessfully to restore adequate funding for firefighters who are among our first responders. As a young member of the House Judiciary Committee, he was selected to present the first article of impeachment of President Nixon during the Watergate affair. Paul is Greek and has remarked that, quote, our word idiot comes from the Greek word idiotos, which in ancient Greece meant someone who leads a completely private existence, contributes nothing to the public welfare. So we don't want idiots in our society, end quote. Third, my fellow environmentalist, Edwin Matthews, a business lawyer in New York, who is lead counsel for 175 members of both houses of the Parliament of the United Kingdom of Great Britain and Ireland in a historic and unprecedented brief amicus curiae in the Supreme Court in the Guantanamo Bay case. The members of Parliament urge that the detainees' cases present disputes that can be determined only by an impartial and independent court, and that indefinite executive detention without judicial review is inimical to the rule of law. Fourth, the growing band of present and former conservative leaders in Congress who are expressing their disquiet concerning the Patriot Act and seeking to rein it in. They may not go so far as others in their statements, but they are spokespersons in a long tradition that includes then-freshman Senator Margaret Chase Smith, who delivered her Declaration of Conscience against McCarthyism on June 1, 1950, at a time when such a statement was a rare act of great political courage. She was joined by only 6 colleagues. Fifth, I would like to compliment Madison, Wisconsin, and the now over 250 cities in the United States that have condemned the provisions of the Patriot Act that threaten civil liberties. As a visitor here, I am the beneficiary of the action the citizens of Madison have taken through their council. Over centuries, brave men and women have courageously defended liberty, risking their lives and careers. They are celebrated in ancient legends, such as Antigone's struggle to give her dead brother a decent burial. In the reports of battles our country has fought for right and freedom. In modern accounts of resistance fighters, combat veterans, and champions of civil rights. And in Nelson Mandela's life story, A Long Walk to Freedom. Tom Fairchild has shown that courage throughout his life, including his challenge to Joe McCarthy in 1952 for the Senate of the United States. His life and career are inspiring. By comparison, it seems little to ask that citizens stand up against the repression of truth, openness, and liberties today. President James Madison, for whom this city is named, understood the Constitution as a people's law, which was to be revered and not remolded by their servants. It seems little to ask that we, the people, stand up for our law, our Constitution. The appropriate responses to terrorism do not include deceiving the American people, needlessly invading our liberty, or enlarging a government of secrecy. They do not include passivity on the part of citizens. If we as vigilant citizens so choose, the spirit of liberty that is in our hearts will become also the voice of liberty in our country. Thank you. Thank you.
Just stay there. I've got to get to it.
Okay, thank you. Thank you. Thank you.
Thank you so much, Mr. Trainer, for those very thoughtful remarks. And as a token of our appreciation, this is the symbol of the law school, the gargoyle, and I guarantee you a conversation starter, I hope, on your bookshelf. Anyway, we will not force you and your delightful wife to have to schlep this back to Berkeley in your suitcases. We'll ship it to you to avoid whatever Patriot Act detection they will force you find in the airport if you go through with this guy.
I'm deeply honored. Thank you.
Mr. Trader has suggested that it's a delight to be back in a college classroom or a law school classroom, and he would welcome any questions. And I just, I don't know if Lynn Thompson or a member of her staff is out there. If we could get maybe refill Mr. Trader's water, I think would be good.
Okay. Who wants to be the first penguin off the ice floe? Let's get it started if we can. Yes.
Know that the facts in and of itself are true. And I'm wondering if you can explain
Good. On the first question, I mean, citizens themselves can't stop a 9/11, but we can support aggressive measures, intelligent measures to strengthen our counterintelligence system. For example, in the preceding administration, and I want definitely not to be political here, counterterrorism activities is a high priority of the Justice Department. The records that are available, and there are only a few on the web, but I'm sure the story is much broader than that, indicate that in 2001, the FBI was asking for some $53 million in funds to strengthen counterterrorism activities by hiring translators, researchers, and counterterrorism specialists. In a letter ironically dated September 10, 2001, the Attorney General deleted that from the budget and recommended that that not be funded. So I think we need, as a government and citizens, to support intelligent and good measures for effective counterterrorism and planning. That's only a partial beginning, but you're right in stating, I think the people who study terrorist acts, the one thing they're willing to do is give up their lives, and they want to demonstrate their fanaticism and prowess, as I mentioned, and do it with a flare, flashing the scimitar or some modern-day equivalent of it. Now, the second question, how do you define a true emergency? I mean, we have to rely a great deal on our elected representatives and our executive. But why can't a court be somewhat involved, at least, in that determination, in reviewing to make sure, under the pre-Patriot Act organization of FISA, the Foreign Intelligence Surveillance Act, a very careful workup had to be made by the Attorney General, and he had to certify personally to the truth of the statements made about whatever the emergency was that justified a surveillance order. Why not? Oh, thank you. Why not engage either, in appropriate cases, the courts, or in some cases, if the legislature is better to review, to have very effective oversight by Congress, or in some cases, as in the case of the inspector generals who criticized the Attorney General for the deportations, inspector generals who are independent and well-financed within the executive department. Okay, yes, in back.
Well, I'm curious, I'm wondering if you're familiar with the work of a Harvard professor named Lane Scarry, who points out that the single airplane on 9/11 did not reach its intended destination was one in which a group of citizens got together and made the conscious decision to sacrifice their own lives by attacking the hijackers, and that therefore the dispersal of information and localized decision-making was actually the most effective technique for stopping terrorism once the hijackers had already occurred. So I'm curious if you could speak to the point that it seems to me part of the problem with the Patriot Act is that it does exactly the opposite. That the evidence that we have now indicates that when the FBI had plenty of information before 9/11, they just didn't use it very effectively. So it's not clear to me how giving them yet more information is going to help. And it seems to me that in fact redistributing a lot of power and information back to ordinary citizens would be a more effective technique.
They're both wonderful points. It's a great example. I have a lot of references to cite when the article gets published, and I will certainly use that one. And I agree with you that if we got better information, we're good people. We're American citizens that can understand these problems. We're resilient, as I said. What we don't want is some fearmonger, and it could be in the form of a government official or a TV newscaster talking about anthrax or something, with being totally uninformed and scaring people. We need to be educated about it, and I think the more information we can be given to share in that and to build up that education, the better, without compromising, as I said, military actions or necessary secret intelligence. So I appreciate both of your points. Yes.
Could you spell out the difference between the rules of prisoners of war as applied, let's say, in World War II, and the rules that are applied to the Guantanamo Bay prisoners of war, or proposals for variations from those?
I'll try to do the best I can on that. The Geneva Conventions, and there's 4 of them, I think the third applies to prisoners of war, has some conditions in it. You get treated with certain human conditions. If you've been caught and you've been fighting in uniform, you haven't been attacking civilians, You've been engaging in what are considered to be, it's hard to think of ordinary acts of war, but military combat where people necessarily are going to be injured and die. I think the government's justification for not according the Geneva Convention treatment is that their claim, at least, is that these people in Guantanamo Bay did not qualify in terms of being in a foreign uniform, fighting for a foreign military. The truth, I think, is we don't know what the truth is, who these people are. Some of them appear to have been turned over by warlords for ransom. And there may be a bunch of innocent people. There may be some very, very difficult criminals in that area. But it's not easy to distinguish. But I think the rationale for the government denying the protections of the Geneva Convention to the people in Guantanamo Bay is that they were not within the definition of what constitutes adequate warlike combat. Yes?
It's my impression that there are demands being made for treatment of those people that were never, treatment that was never given to prisoners of war during World War II. They weren't given rights to courts or anything. They were given food and lab, period. I mean, they had no rights to court cases and that sort of thing.
Well, we were in a war, and then when the war ended, they were returned to their homelands.
Well, right.
And they were given, by and large, with the exception, I think, of some cases, particularly including the Japanese internees, were treated not brutally, but they weren't given access to courts and so forth, but they were returned, and it was a definite period of time. We've got these people in Guantanamo Bay. It's indefinite. They've been down there about 2 years. No charges have been filed against them. You know, but they were. But do you feel that that's a precedent for Guantanamo Bay?
I just wonder what rules are to change. I'm just trying to find out. I mean, I don't want to make a decision.
Right now, the executive is claiming the power, unheard of really in our country, to be able to label anybody it wishes as an enemy combatant, and that's a term of art. That's not a prisoner of war who's entitled to the Geneva Convention. To label anybody an enemy combatant, including a United States citizen, and put them and detain them indefinitely, and not allow them to talk to a lawyer, not allow them any judicial review to determine whether the even basic reason for their being detained is adequate or not. And if you think that's a good thing, then I think we'd be in disagreement about that. Yes?
I think that the 11 evaluations have not been thorough and careful and thought out in a way that I find very dismaying. For instance, as I watched the planes crashing in to the horrible sights of the 11th, I just thought how the terrorists had used our transportation system, considered as a whole, as a way of blackmailing our citizens and striking fear into them. And I was thinking of practical things, like what if we would do a better job of improving the rail system, so that if people want to travel on interstate trips, they can do that if they want to. Same with the highways. You go out at the highway and just look, and there are huge trucks, and there's traffic that's so frightening that it's no wonder that people want to go by plane. Look at the after effects of the war, which plunged us into the worst deficit that we have ever had in our country, and none of the effects of that desperate deficit have come home. And yet I see our superintendent of schools and our members of the school board being vicious with each other because they're discharging 20
teachers, and there are stopping sports and stopping schools at this and that, and it hasn't even started yet. So I think that what we need to do in our society is pull up our socks and start concentrating on some analysis and do something about taking the terrorism by the throat and trying to keep the terrorists from blackmailing our entire society. And that's not necessarily, I mean, although very importantly is the law, but we have to start working as a society to preserve our I'm a conservative about the Bill of Rights, and I thank you.
To me, two things come out of what you just said, at least in terms of my reaction personally. One is it's very important for citizens like yourself and all of us to engage in discussions like this to see what the best answers might be. And second, to really question the priority that's being given to anti-terrorism activity. I mean, why should it be a priority to attack our liberty? Why shouldn't it be a priority to do what we really haven't done yet, for example, and that is to ensure better security at our ports and our container facilities and our means of transportation? Yes, right in the middle.
How can an individual running for public office attack the Patriot Act and avoid being charged with being unpatriotic without giving a classroom lecture?
I think being honest about how they feel and how they feel about our country's liberty. I want to. I think you struck a chord because I think politicians should be bolder than they are. I wish more of them would speak out. I think what Senator Feingold did. I mean, imagine being the only dissenting vote shortly after 9/11, when there wasn't much time for debate, and that's one of the problems. And he cast a dissenting vote. And I think people are beginning to see now that there was an overreaction in the Patriot Act, and some people are going to rein it in. But there's a couple of one-sentence quotes I want to just refer to because they bear on your question. One is by the Attorney General. In December of 2001, in his testimony to the Senate Judiciary Committee, and this reflects what you say about the fear-mongering, quote, "To those who scare peace-loving people with phantoms of lost liberty, my message is this: your tactics only aid terrorists, for they erode national unity and diminish our resolve. They give ammunition to America's enemies and pause to America's friends," end quote. And then in the Padilla case, which is one of the cases involving an American citizen, Admiral Jacoby, who was the head of the Defense Intelligence Agency, filed an affidavit in which he says, "Anything that threatens a perceived dependency and trust between the subject and the interrogator threatens the value of interrogation. Any contact with a lawyer can undo this work. Only after Padilla has perceived that help is not on the way can the United States reasonably expect to obtain all possible intelligence." So you have public officials in high places making assumptions that to attack and to challenge what they're doing to our liberty is somehow un-American. I think we have, as citizens, have to help our leaders, our politicians, our representatives, to have the moxie to stand up and resist that kind of statement. When the Attorney General, for example, says that to members of Congress, there ought to be immediate opposition to that sort of thing. It's the kind of thing that happened during the McCarthy era. And I guess, is it too much really to ask as citizens that we elect representatives who are willing to say those things and to make those kind of challenges as Senator Feingold did from Wisconsin? It was, yes, in the front row there.
Do you think that perhaps beneath our necessary search for remedy to potential acts of terrorism that might loom in the future. That we need to be hard at work at learning how to understand the root causes of terrorism in the world. And if you do think that, how can individual, ordinary citizens do as you suggest, stand up and insist that part of our efforts, scholarly, government, and individual, be devoted to defining and figuring out how to work with people who might be inclined toward terrorism to help them expand their personal horizons and find some other ways to view life. Is this an unrealistic hope?
I would hope it's not an unrealistic hope. I mentioned education. I think it's going to be important for all of us to learn more about these enemies and supposed enemies of ours. I don't know the Koran. I plan to learn more about it. Sometimes the terrorists will refer to passages in the Koran and justifying or explaining some dastardly thing that they've done. I think we need to understand their culture more. If there are ways to reach out to people who are Islamic but not violent, to help them and cooperate. But to arrogate to ourselves as one country the idea that our Judeo-Christian ethic is the supreme one to win in some sort of crusade. The president was quoted, I think, by Woodward as saying, he was asked, did he talk to his father? No, he talked to a higher father. Well, that's a connotation that this is some sort of spiritual crusade that where people who are of the Islamic faith and Muslims are against us. I don't think that's true at all. And I think if we learn more about them, as I believe you're suggesting, if I'm hearing you right, it's going to take a passage of time. We're going to have to start with some exceptions, obviously, but we're going to have to start from a fairly rudimentary base to learn. Yes, in the back.
I watched President Bush give a speech on the Patriot Act this week, and his main point seemed to be, why can't judges and prosecutors have the same powers that they already have to go after organized crime and drug laws, stuff like that. Most of this stuff they can already use against criminals, and why can't they have those same kind of powers to go after terrorists? And I think that's a very effective argument. Do you think that's an interpretation?
The argument is based, and you hear it in more legal contexts, the argument is based, we've always had these powers, and we have them through grand jury subpoenas, and this is just another way of law enforcement. I think there is an answer to that, and I understand the political effectiveness of those remarks. But with a grand jury subpoena, a court can review it. Not a secret court in a bunker in the Department of Justice building in Washington, D.C., but a court in the area where the grand jury is sitting. A grand jury subpoena can be challenged before a court as unreasonable, as calling for information that's not relevant, as calling for information that's privileged, such as privilege under the attorney-client privilege, as calling for material that's protected by the First Amendment. And the Brandsburg case in the United States Supreme Court sets forth some limits on that. It can be done via a motion to quash or limit a grand jury subpoena that's presented to a court. You can also challenge, there are limits on what you can do by way of a gag order with a criminal or grand jury subpoena. Under the Patriot Act, the gag order is right in the statute. You shall not disclose this to anybody. Under the grand jury rules and under the other rules that the President and law enforcement are referring to, basically witnesses are not precluded. There has to be a separate order from a court. Under Rule 6E of the Federal Rules of Criminal Procedure, witnesses are excluded from the people who are usually subject to grand jury secrecy. And there's a whole lot of uncertainty, but it's not at all clear that witnesses themselves before a grand jury are subject to an automatic gag order. So it's a very different situation. Now, I wouldn't be opposed to having judges involved in carefully reviewing the circumstances, but to just do it in one secret court, which has now issued over 15,000 orders in only one time that I'm aware of, did it not go along with what the government had said, and it didn't reject the government entirely, it modified it. All 7 judges of the secret court acted in what was, I think, a courageous decision, saying, government, you've asked for too much, we're modifying your request, and in the one and only time that there was an appeal, they got reversed by the Special Review Court. But in the 25-year history of the Foreign Intelligence Surveillance Act, there has been over 15,000 secret surveillance orders. That's less than 1,000 a year. The last number I have for 2003 is 1,700 or more. In 2002, it was some 1,200 or more. The government's clearly making much greater use of secret orders. And then when it comes down to our understanding, well, how many orders did you get for 215? And how many orders did you get for sneak and peek? And how many did you get for wiretapping or surveying the internet? All of that's classified. And that's supposed to be reported to the secret intelligence committees in both subcommittees in both the House and the Senate. We don't know, as Americans, whether they're doing their job as reporting. So we don't have, I grant you the political effect. That's there, but it needs to be countered. And I'm trying to counter it here.
I think we have time for maybe one more question, and then we'll have our reception. And those of you who want to pepper Mr. Trainer some more can do it outside.
I just have a question. You made passing reference to the press in your speech, and I wonder if you could tell us what role the press can play in a time of repression, and then what role you think the press actually is playing in a time of repression. And I guess my question gives my bias away, but
what's your bias?
I'm not so sure they're playing the right role, but I certainly don't want to put too much blame upon that, but I wonder if you could expand a little bit on the role you think that they could play and that they may be playing.
I think they could be far more diligent in asking tough questions. I think when you get a press conference, you get sometimes people in the Washington press corps, and they don't get a chance to follow up. They're dusted off. The media training people will say you don't have to answer the questions that ask. There ought to be some way to have questions like cross-examination, so there's a series of questions, and it becomes part of our expectation as citizens of our reporters that they're going to be asking one follow-up question after another until they get the answer that they're entitled to. I don't think they're doing the job now. I think that sometimes they're also engaged in scaremongering without the facts. I think we had some of that during the anthrax scare. When people, if we tried to educate us about what anthrax is, what the dangers of it are, how long it lasts, and so forth, instead of saying, there's been the mail of anthrax, everybody should get worried about it. So I think they need to be better prepared, certainly more vigilant, certainly tougher in their asking of questions, and not to just sit down and have an answer fobbed off on them that's a public relations statement, but to call them on it. That's what I think.
Thank you. Thank you very much.
Thank you. Thanks, Tom.
And everybody is cordially invited to join us at the reception outside, which will start immediately.